open session. The Honorable Mark A. Herman presiding.
Please be seated. We'll go on record in the court's morning sentencing docket on Friday, May 30th. And looks like Mr. Feldman is here. So first matter we'll call is file 25-10033 FH. People State of Michigan versus County of Nicole Wallen. And I see Miss Wallen on the Zoom. Can you hear me, Miss Wallen?
Yes, I can hear you.
All right. Your attorney, Mr. Feldman, is present here in the courtroom. And on behalf of the prosecutor's office, Assistant Prosecuting Attorney Jason Browning. This matter is on the court's docket for sentencing on charges of 3 counts of resisting and obstructing police. And I did receive and review the pre-sentence investigation report. Had a chance to review it and make use of the report in making a decision. Attorney Rowning, did you get a chance to receive that information, review it, and go over it?
I have received the pre-sentence investigation report. I've had a chance to review it and have no objections or corrections.
And Attorney Feldman, did you get a chance to review it and go over it with Ms. Wallen?
Likewise, I had a chance to review it. I emailed her a copy yesterday and had a short conversation over text with her this morning. She's reviewed it. We saw no inaccuracies. I would note I did try to send in a brief sentencing memorandum yesterday. Something happened with the email. I contacted Mr. Rowning. I sent it to the court and staff. For some reason, it didn't come through. I think something was going on with our email yesterday. And it was simply a letter from Healthy House for Women in Kalamazoo that she is a resident there now. The court had inquired when we discussed whether or not she could appear over Zoom today as to how long it's anticipated she'll be there. And that is a minimum of 6 months stay at Healthy House for Women, possibly up to 2 years. All the programming there is to help to support them in their recovery. They attend daily AA or NA meetings, random screenings. It's more of a step down from residential than it appears anything else. And I did have also a copy of her certificate of achievement. She did graduate Bear River, so I will try to get those to the court again later on today. But
yeah, I pulled up another screen. It doesn't appear, at least it's in the clerk's office, QE, you know, that they've got it, so.
okay, I'm not sure what happened with the email yesterday. It populated with the auto-generated addresses, so I'm not sure why, but the court had inquired about those, so I had those and can just proffer as an officer of the court that it's a 6-month program minimum up in Kalamazoo, up to 2 years.
All right. So, Ms. Wallen, did you hear Attorney Feldman? He indicated that he received the reports, got a copy of you, and had a chance to go over them with you. Is that correct?
Yes, sir.
Did you have any additions or corrections that you wanted to make to the report?
No, sir.
All right. I will give you an opportunity to make a statement to the court if you choose. First, we'll hear from Attorney Rowning on behalf of the prosecutor's office. Then we'll hear from your attorney on your behalf, and then I'll give you a chance to make a statement if you choose. Attorney Rowning.
Your Honor, I remember when this case came in initially, the video or the videos of the instance were very troubling, and I think, I hope Ms. Wallen appreciates the opportunity she's been given. Her behavior that day with those police officers was incredibly unacceptable. She had completely lost it. It became violent and thrashing, headbutting, biting and spitting, and just acting out in incredible ways. I think, though, that her behavior in those videos does explain the benefit that she's had at a place like Bear River and the place she's at now, where I think she may be getting the treatment that she needs to help deal with those issues. I just hope that moving forward she appreciates her opportunity here, the risk she has if she fails to complete her programs, and does have a probation violation, and takes advantage of the programs that she's in. Based upon all those factors, Your Honor, we ask the court sentence within the guideline range.
Thank you. Attorney Feldman.
Thank you, Your Honor. I viewed the video. It was awful. We hear the term mental breakdown, mental episode, those kind of terms thrown a lot in court in this business, and I'm certain that Mr. Ryan feels the same way. If the court watched it, he would say that's exactly what happened on that date. So for her to take the big step of surrendering herself to, I need to change and I need to take myself out of the environment that I'm in to do that, and to step away from the life that you have in the place you were raised for a minimum of a month to go do the residential, and then to be willing to step down to something that's maybe just a little bit less intensive but no less invasive, bodes well for her. I would have been very concerned if she didn't finish Bear River, if she had walked from it or something like that had happened. And I would probably be still concerned, a little less concerned so, if she had left Bear River and came right back to where she was at the time this happened. But those are two positive steps. Going to Bear River and completing it is a big one. But then understanding that there's change that still needs to be made, and surrendering yourself to half a year of people involved in your life on a day-to-day basis, and governing where you go and who you're with and what you do. Those steps of surrender bode well for her to continue this better life path that she's on.
Ms. Wallen, is there anything that you want to say on your own behalf?
I just want to say that I am extremely grateful for the opportunity that you guys have given me. I really feel as if my mentality and my mindset has changed drastically since I came from Bear River. I feel like I'm learning more about myself every single day. I'm learning how to control my emotions, my bipolar. I'm on the right medicine now, and I feel as if that's helping also. And I feel as if I have a lot more support here than I did at home. And I feel as if I really am taking a really big step towards getting to where I need to be and doing it the right way this time. But that's all I have to say.
All right. You took the opportunity to thank us, for giving you this opportunity, but you need to thank yourself, because we can only give you the opportunity, but you're the one that has to accept it and do the hard work and make changes in your life. You're a young lady and you have a long life ahead of you, and so I do hope that you take the opportunity and you do use it, and that realize obviously when you get out of the programs there are going to be support services and people that you can talk to and contact if issues come up in the future. But I have to agree with Attorney Ronning and Attorney Feldman. When you look at what happened, this whole incident, it really was kind of an out of control situation when it happened, and specifically what had happened in this case. Ms. Wallen, on January 28th this year, approximately midnight, the Wajack police were called to Riverside Apartment 13, and when they arrived, they could hear screaming and arguing coming from the apartment. Officer Kusa knocked on the door, made contact with your sister, who was bleeding from her mouth, advised that he would hit her in the head with a speaker, punched her several times. Officer Garrad and Deputy Chief Roman arrived on scene, and you were advised that you were under arrest, and you walked away and into the bedroom screaming. As the officers grabbed you, you pulled away and began to kick and scream. You then kicked Officer Kusa, headbutted Officer Garrad. While being transported to jail, you spat at the officers. So as a result of your over-the-top reaction to the officers, you now have these 3 felony convictions on your record. So what happened here wasn't a good choice. If you just cooperated with the officers, you might have been charged with a misdemeanor. And so, and I suppose under that situation, and I realize there were probably some extenuating circumstances you've indicated, there wasn't any way you were going to get away from these officers, so fighting with them wasn't going to probably make things any better for you. And I look at it with what you've done. I'm very impressed that you went to Bear River, that you then entered the program, and maybe in hindsight, it's a blessing for you, because if you hadn't gotten arrested, hadn't had that opportunity to go to Bear River, be where you're at right now, if you'd have just got charged with that misdemeanor, you might be back on the streets, back in the same situation, and be having more problems. So hopefully you can look at it somewhat as a blessing in disguise, that this whole situation happened, but you're now in a much better place, and everything that I'm hearing about your progress is positive, and I want to just congratulate you on that. You know, you're 20 years old, certainly you have an anger management problem, obviously, you need to address that. It sounds like you are. You've got your medications in line, and you've got a lot more support where you're at. At the time of this incident, you're on probation out of Muncie, Indiana for an assault and battery, and you have some other charges, I think, pending in Muncie, and so. And I note, obviously, when I looked at the report, you've got 2 children, correct?
Yes, sir.
And they're currently in the custody of their grandparents. And also note that you dropped out of school in 10th grade. I hope that as part of the program that you're in now, that you're going to be moving forward and exploring at least getting an education, either a GED or high school graduation. So. And I note that you were attending the GE prep classes at the time of your arrest. So are you engaged in a program such as that through Bear River?
I was doing my GED, but the school year is over, and she told me that I can always re-enroll next year, and all my transcripts and all my schoolwork will still be saved, so I can just start back where I left off.
Okay, well, I'm going to just hope that you do that. It's obviously going to benefit you as you move forward in life. It's also going to benefit your children. So make sure you do something like that. Since the incident, as we've discussed, you entered the Bear River Rehab Treatment Program. Upon completion, we're transitioning to sober living, either in Kalamazoo or Battle Creek. And are you in Kalamazoo?
Yes, sir.
Okay. And it looks like you're starting to take control of your life, Ms. Wallen, so I'm going to give you the opportunity to keep moving forward without any additional jail time at this time. But again, I think it's real important if you violate probation and you come back before the court, you could be looking at a good long time in jail. You know, when we look at your guidelines up to a maximum 17 months, the reality is if you're not serious and take the program seriously, I would expect the prosecutor to probably be recommending that I give you a year in jail. And the reality is that's something that I'd look at. I don't want to do that. I hope you move forward in life. And I'm impressed with what you're doing, and just keep moving forward, and hopefully we won't see you, all right?
Yes, sir, I appreciate it.
Yeah, so what I'm going to do on the counts 1, 2, and 3 charges of resisting instructing a police officer will be sentenced to court. You can be placed on probation for a period of 2 years under standard terms and conditions outlined in the pre-sentence investigation report. There will be a supervision fee of $720 to be paid for date approved by your agent. Also, some of these things I'm going to order, you've probably already done, or that you participate in substance abuse and mental health assessments as recommended by your agent following a recommended course of treatment, including an MRT and anger management program. I'm sure those are all kinds of things that are being set up through the program. I'm going to order that you serve 85 days in Cass County Jail with credit for 85 days that you've already served. So as we've indicated, there won't be any additional jail time that will be imposed here. There will be a $68 minimum state cost on each count, a crime victim rights assessment of $130, attorney fees in the amount of $350 to partially reimburse the cost of providing legal representation in this matter, and court costs in the amount of $500, which the court deems reasonable based on the average cost of prosecuting a case here in the county. You shall also comply with and pay any associated DNA testing fee, which shall be assessed at $60. There was no restitution request in these matters, is that correct?
That is correct.
All right. So there's no restitution to be ordered by the court, Ms. Wallen. I just want to give you some encouragement, stay in the program, and hopefully we don't see you back. Ms. Wallen, you are entitled to file an application for leave to appeal of your sentences or your convictions in these matters. If you're financially unable to retain an attorney to represent you, you may request that the court appoint an attorney to represent you on appeal. Any request for an attorney to assist you in an appeal needs to be made within 42 days of today's date. Since you're not here in court personally, Ms. Wallen, I'm going to have the court staff mail you that notice of appellate right to review. Just ask that you review it, initial it, and return it back. And again, if you wish to appeal, you can fill out one of the forms completely, return it back, and I would review it. Do you have an address that we can mail that to you?
Yes, it's 713 Simpson Street.
Simpson?
Yeah. Kalamazoo, Michigan, 49007.
All right, we'll go ahead and get that sent off to you. There'll be some instructions in there. If you do have any questions, you could contact either Attorney Feldman or the court. Good luck, ma'am, and keep working hard, all right?
Okay, thank you.
You're welcome. Attorney Ron, anything further in this matter?
No, Your Honor, thank you.
Attorney Feldman.
Nothing further, Your Honor, thank you.
All right, Mr. Wallen, if you have a pen or pencil handy. Miss Wallen, can you hear me?
Yeah, I have a pencil.
Okay, I'm gonna give you a phone number here, 269-445-4404, and that's the probation department.
Can you say that one more time?
Sure, 269-445-4404. And probation agent, just call them, give them your contact information, and they'll set up some time to meet with you to go over a probation contract, all right? So that when you get out of the program at Bear River, if you do get out and are placed back in the community, then what kind of contacts you'll need to set up with them, okay?
Okay, thank you.
All right.
I messaged her that information if she can transfer that up to Kalamazoo as well.
All right. All right, you can go ahead and sign off, Ms. Wallen.
Okay.
All right. All right, Attorney Hogue, I see you there. Do we have Mr. Martinez?
Mr. Martinez, I'm the best guy, sure.
And I believe is that him that they've got in there? All right.
There.
Go on record and file 25-10006FH, People State of Michigan versus Luis Antonio Martinez Jr. Mr. Martinez present via Zoom from the Cass County Jail. Mr. Martinez, can you hear the court?
Yes, sir.
All right. Your case is on my docket for sentencing here today on a charge of possession of methamphetamine, and for purposes of the sentencing here today, I did receive and review the pre-sentence investigation report and the sentencing information report prepared by Agent Browning. I also did receive a report and recommendation regarding the by Monique Church in reference, and Dr. Howes in reference to their recommendation for participation in the Swift and True program. Attorney Brown, did you receive all that information, get a chance to review it?
I have received the information, I've had a chance to review it, and have no objections or corrections.
All right. And Attorney Hogue, you had a chance to review that information, and
I have received both of those reports that you referenced, Your Honor. I have also reviewed it with my client. We have no objections at this time regarding the information pertaining to those documents.
all right. And Mr. Martinez, did you get a chance to review that information with your attorney?
Yes, sir, I have.
Were there any additions or corrections that you wanted to make to the information in the report?
No, Your Honor.
All right, I will give you a chance to make a statement if you choose. First, I'm going to hear from Attorney Ronning, and then I'm going to hear from Attorney Hogue on your behalf, and then I'll give you that opportunity.
Yes, sir.
Attorney Ronning.
Thank you. Your Honor, the only thing I would like to put on the record is that if the court does proceed to put the defendant into some sort of a problem-solving court program or Swift and Sure, I hope that the defendant takes advantage of that and recognizes that with his criminal record and his PRV scores, any future violations will almost positively send him to prison, and jail won't even be on the table. And so I hope he takes advantage of those. If he chooses not to, then that is going to be the result. Thank you.
Mr. Martinez, I've had a couple opportunities to speak with him in depth regarding the situation that he's in before the court. At no time has he ever tried to minimize or discount what his charges have been, especially after he's accepted responsibility with his plea. But I think this court sees this type of case quite too often, unfortunately. A young individual, Mr. Martinez, had started using drugs as a young individual and has continued to this day. He was almost had his life trajectory corrected. However, there's negative things that always happen in our lives impacted Mr. Martinez, where he led him to relapse, and we understand that part of recovery is relapse, and again, that's not an excuse, that is just part of the system that we are dealing with. Unfortunately for Mr. Martinez, he was at a position where he had some resources in front of him, but I don't think he had enough of those resources, Your Honor. And I think the recommendations for the Swift Assure program will be enough for Mr. Martinez to not only engage again in recovery, but also engage in it and stay within it. I think it's so important to always strive to, today I'm going to be clean, tomorrow I'm going to be clean, 3 days from now I'm going to be clean, 5 years from now Mr. Martinez will be clean, and I hope he is. I spoke with him earlier and we talked about different things, what he's trying to do, and he understands that he has a huge deficit to overcome to maintain his ability to be a productive member of society. As Attorney Running just indicated, and I've shared this with my client as well. If he's unsuccessful during this term of probation, if the court sees fit to allow him to enter the Swift Mature program, which I hope they do, that if there is another misstep on his part, it is going to be a straight go to jail, go to prison, don't look back kind of situation. And I don't believe that Mr. Martinez wants that. He's never been to prison, as is indicated in the PSI. He's also never had the true benefit of a program. Now, he was in the Twin Counties program, and I know there was some programming there, but I don't think that he had the type of oversight that Swift Assure is going to allow and provide for him, Your Honor. So at this point, I would request the court to allow Mr. Martinez to enter into the Swift Assure program, attend Twin Counties, and be able to get his life back on track where it needs to be. Because if not, it's either going to end in death or in prison. So I don't want to see that. I want to see him be out among us and providing a positive impact on everyone's life instead of a negative one. Thank you.
Thank you, Attorney Hogg. Mr. Martinez, is there anything you want to say on your own behalf?
Yes, Your Honor. I'd like to thank Mr. Hogg for the opportunity he's going to give me by group to the Swift Assure program. I was in the regular MRT program. I was doing well. I was clean 9 months, long everything in my life. 4 months in the program, probably I had a relapse. Due to my case, I apologize. I was caught with a small amount of amphetamine. I'm not a drug user, I'm a drug user. Given the Swift Assure program, I will complete it 100%, no issues, no problems. And I'd like to say, on behalf, I apologize for inconveniences. And I just I'll give you the chance and opportunity to do this Swift Assure program. That's it.
All right. All right, well, Mr. Martinez, you and I are no strangers to each other, right?
Yes, sir.
I think I gave you a jail time back in 2019 of like 240 days. I think 2022 I gave you a year in jail. And then here we are back again for possession of drugs. Tell me why you want this program.
When I was given the opportunity in the MRT program, I did well. I had no write-ups, no sanctions. I completed the program 100% correct. I had no issues with jobs. I know if I was given this opportunity, I'll complete the program very well. Like I said, I fell down. I relapsed. I apologize for my relapse. There's no excuse for my relapse, like folks said, because there's no excuse for my relapse. But I relapsed, and I'm picking myself back up. During my incarceration, I've got a certificate for a parenting class. I've got a certificate for a substance abuse class with Shane from Woodlands. I'm trying to stay on the right path here and upon my release to stay on the right path.
And you're 39 years old?
I just turned 40 2 weeks ago, sir, a week ago.
Oh yeah, May 26th, so you just turned 40. Happy birthday.
Yes, sir.
Obviously, sitting in jail, obviously, is probably not how you want to spend your birthday, but You got a lot of birthdays ahead of you.
Yes, sir.
And if you want to make some changes in life, you're really getting at an age though where either you make them now or it's going to be hard for you to catch up in life. And I hope you appreciate it. You probably think you're a young man, and to me you are, but I mean, in reality, if you look at moving forward in life and doing something positive and really having a good life, you've got a lot of years and the ability to do that. But you're really at that age, and if you don't start it now, because I think as the prosecutor said, and as well as your attorney pointed out, when you look at your guidelines because of your criminal record, your history, the reality is, and as I've indicated, I've sent you to jail a few times in the past for some extended periods of time. So if you're not successful, the reality is if we give you this opportunity, that the likely outcome would be that when you are in court next time for violating, that the only option that I'm going to have, and I'm sure the prosecutor's recommendation is going to be that you go to prison. And that's not something, and obviously if that happens to you, you're going to be behind that 8 ball and probably never be able to catch up. So I hope you think about every day that you're really at that point in life where either you do it now, or the reality is you're probably never going to get it done. So, all right. Ms. Smith, I know there was a recommendation that Mr. Martinez go to Twin County. Is that something that's available either today or in the near future?
It would be, Your Honor, and that is the plan for Mr. Martinez if he is ordered to the Swift and Sure program as a condition of his sentence today. However, he does have a hold out of Berrien County for a possession charge. It has a $1,500 cash-only bond. When he releases here, if that hold remains valid, we'll return him over to Berrien County. Once matters are resolved in Berrien County, we would make arrangements to pick him up and transport to Twin County. So I think things are a little on hold pending resolution in Berrien County.
All right. All right, Mr. Martinez, so that you understand, I'm not adverse to giving you this opportunity, but there is a hold in Berrien County. I don't have any control what Berrien County does, but the fact that you've been ordered into a program here, there's a likelihood that Berrien County would go along with our agreement here with you and would give you that opportunity. So, but again, we can't guarantee what Berrien County would do, because obviously when you look at your guidelines, when you look at the fact that you're charged in Berrien County as well, you're probably looking at prison guidelines in Berrien County. So it's possible they could do that. So I hope you realize that you're at that, really at that point, at the cusp in your life that you probably, the next time you're before the courts, you're going to prison. And if Berrien gives you the opportunity and puts you on probation and lets us supervise you through that program. The other thing you need to realize is with 2 courts, you could get prison sentences if you violate in 2 different counties.
Yes, sir.
And so you could end up serving a longer period of time because of those 2 cases. So you may be given the opportunity, hopefully, to make some changes, and if you don't, then you're looking at some pretty serious consequences. Well, in this case, Mr. Martinez, on December 29th of last year, you were passing your car driven by a Samantha Jewell that was stopped shortly before 9 p.m. in Dowagiac because the Secretary of State had a confiscate plate order and lien for fraudulent application of insurance on the vehicle. You were asked for your ID and you ignored the officer, but Sergeant Pompey recognized you, believed you had an outstanding warrant, asked you to step from the vehicle, at which point you just rolled up the window. Sergeant Pompey knocked on the window, informed you that it was not a request but an order, and fortunately at that point you complied, got out of the vehicle, produced your ID, and you did in fact have a outstanding warrant out of Berrien County, the charge that we were discussing, for failing to appear on a probation violation, and you were arrested, patted down, and placed in the patrol vehicle. And you're lucky that's really where you went, because you were close to being scored an additional 10 points on an OV-19. And what that could have done I looked at it and I said, you cooperated after he told you to get out. If you had resisted them in any way, you could be looking at adding even another 15 months on the top end of your prison guidelines. So in the future, just so you appreciate, if the police ask you for that, cooperate, because even not cooperating a little bit, lying, whatever, can really increase the potential top end of your guidelines on a minimum sentence. So I looked at that and thought, well, I don't think we need to score that based on your compliance once he had you step out. But you know, so think about what you do in the future when you deal with police. I always tell people, you deal with the police, just cooperate. It never gets any better for you if you don't. You know, even if you disagree with the stop, that's what you discuss with your attorney, and you address it that way. Now, in this case, the vehicle was impounded, an inventory search was conducted, and various items of drug paraphernalia and pills were located between the passenger seat and the center console floorboard, as well as in a cream-colored mini purse, which is bearing the name of George. A secondary search was done on you, and the officers did locate a brown vial containing methadone in your inside coat pocket. And as usually the case between cohorts and crime, as in this case, Miss Jewell denied any knowledge of the drugs in the vehicle and blamed them on you. And you, on the other hand, denied all knowledge of the drugs in the vehicle and blamed them on her. But be that as it may, you did have meth in your pocket, and so even if you didn't know what was in the vehicle, you did have that methamphetamine in your pocket on your possession, so you're here for sentencing on that charge. You're 40 years old, as we've indicated, just had a birthday, and this is your 7th felony conviction. You have a 10th grade education, according to PSI, at least a 20-year meth addiction, off and on, as you've indicated. You did indicate there are some times possibly that you had been tried to get clean and maybe had been clean for a while, but you did relapse. When I looked at the report as well, it looks like both of your parents did time for drug delivery charges as well. And based on the criminal history, your guidelines, as we've indicated, could see you go to prison today. I know from the PSI that you've never been to prison, and but you've spent about 3.5 years in jail at various times over the years too, and I pointed out a couple that you've had with me. So I hope you have some other plans going forward in life, as we've indicated, other than just floating along and seeing where life leads you. Because that's when I look at you, and I hope you get some direction in your life, because it looks like you're just kind of going along and kind of letting life, you know, come at you as it comes at you, and then that's kind of what you're doing. So hopefully you get some goals. You think of where you want to be in a year, where you want to be in 2 years, where you want to be in 5 years in your life, and work towards those goals. You still have that ability to do that, but you've got to do it now. And it doesn't look like in the past that you've really done that. You've just kind of gone along in life, and you know, whatever comes along kind of comes along. So, and as we've indicated, you're at that point at your age that you got to make some major changes in your life, or you're going to have to resign yourself to the fact that you're going to, from moving forward, if you don't change, you're just going to have a life in and out of prison from here on out. And hopefully you want to avoid that. I'll give you the one last opportunity to avoid that prison sentence, and I'll give you that opportunity in the Swift and Sure program. I do have that assessment. It recommends the Twin County Community Probation Program as well. And I know that you already successfully completed it one time in the past, correct?
Yes, sir, the regular MRT program.
Right. So what do you need more? That's the initial part of it. You completed that program. What caused you to relapse?
No, I lost my friend, stabbed himself to death during that time, and then my grandmother passed away 2 weeks prior to being arrested. I did sign up for Carol's Hope because I wasn't going to rehab. The day I was supposed to go, I was arrested the night before.
And I want you to think about what you just told me, because guess what? Nobody gets through life without having bad things happen. You know, your grandma died. You know, you're going to have friends die. You're going to have siblings die, brothers, sisters, whatever. And so when those things happen, you've got to make sure you're in a position to move forward in life in a positive direction. None of us get out of life. Those things happen to all of us. So get yourself in a position where you realize those things are going to happen, and that you don't turn to drugs as as a solution, because as you see, where you're sitting here in front of me, drugs aren't a solution. They only compound the problems. People always say, I'm gonna do drugs, it's somehow that gives me an escape. It doesn't give you an escape, it just compounds it. It makes your problems worse, and then you end up in a situation like you are here. So I hope you learn that, and when you go through the program again for Quinn County, that you think about that and look at the aftercare programs. The recommendation, swift and sure, I'm gonna give you that opportunity, but I think as well as the prosecutor stated, I've stated, I think even Attorney Hogue alluded to that fact, and even the agent in the report indicates, he's recommending swift and sure. Know that you've never been to prison, but he says if you're unsuccessful, prison would be the warranted result. So that's kind of where you're at. So I'm gonna give you that opportunity, and hopefully you take it. The one thing you need to realize that when you're in that program, Mr. Martinez, I don't know if you like seeing me or not. You probably don't, because I've sent you to jail a few times, and now I'm sending you to a program and potentially looking at someone that could send you to prison. But when you're in this program, you're going to be seeing me monthly. You're going to be in court with me monthly. I'm going to be monitoring your progress, and I always tell people, don't try to do the least that you can to get through these programs, because if you do, you'll end up failing. So don't try to say, okay, what's the least I can do to get through the program? Because if you take that position, sooner or later you'll violate probation and you'll be back here in front of me for sentencing. I hope that's not the case, and you take the opportunity seriously, but you can't say you weren't forewarned by everybody as to what the consequence is going to be. So what I will do on that count one charge, possession of methamphetamine, be sentenced for you placed on probation for a period of 3 years under the terms and conditions outlined in the pre-sentence investigation report. Pay a supervision fee of $1,080 at the rate approved by your supervising agent. I will order you enter and successfully complete the swift and sure sanctions probation program, comply with all the requirements of any participant agreement. As a condition of the swift and sure probation, you shall also enter and successfully complete the Twin County Community Probation Center and participate in an educational or GED program as directed by your agent. I will order you to undergo a substance abuse and or mental health assessment as directed by your agent, and you complete any recommended services and programs. As a further condition, I will order you to serve 153 days in Cass County Jail with credit for 153 days already served. Or to pay $68 in minimum state costs, a crime victim rights assessment of $130, attorney fees in the amount of $350 to partially reimburse the cost of providing legal assistance in this matter, court costs of $500, which the court deems reasonable based on the average cost of prosecuting a case in the county, and order to pay a fine of $500. There was no restitution requested, and none will be ordered. I will advise you, Mr. Martinez, you are entitled to file an application for leave to appeal. I see the deputy there bringing that notice of appellate rights to you. Going to have you acknowledge receipt of that. You'll receive 2 copies of that form. If you do wish to appeal, you can return one of them completely filled out, and I would review that, and if you qualified, would appoint an attorney to assist you in any appeal if you requested that. If you did wish to request an attorney to assist you in an appeal, Mr. Martinez, you can make sure that you submit that back to the court within 42 days of today's date. What will happen then is, based on the sentencing here today, Mr. Martinez, you'll be returned to Berrien County. If they're in agreement with you participating in the program, then they'll let you know about that over there, okay?
Sure.
All right. Attorney Ronnie, anything further from the people?
No, Your Honor, thank you.
Attorney Hogue?
Nothing else this time, thank you.
Mr. Martinez, do you have any questions for the court?
Thank you, Roger. I appreciate you all.
All right, and I look forward to seeing you on a monthly basis if Berrien County gives you that opportunity, and I'm looking forward to you becoming a productive member of the community, all right?
Your Honor.
All right. Ms. Smith, anything further from Community Corrections?
No, Your Honor. Good luck, Mr. Martinez.
All right.
Thank you, Madam. Thank you.
We'll go ahead and adjourn this matter then. Attorney Drake, do you have this, Mr. Suge? Mr. Kardotsky, I noticed your client was running late. Is he here?
Not yet, Your Honor.
Okay.
Texted him asking about the EPA, and I haven't responded.
All right.
Your Honor, may I approach? I have a document for the court.
Absolutely.
I just provided a copy to the prosecution. Already done to get for his father. Last time the court was gracious enough to get us in the journal for him to deal with that. And I think he just wanted to, show proof that it was not a delaying tactic, that it was an actual event.
Sorry to hear how the cause too.
Yes.
Well, we're here for sentencing in file 25-10019FH, People State, Michigan versus Philip, was it Suge or Suge? Suge, okay. We were previously in court on May 2nd. We did adjourn it based on the fact that your father was passed. And so with that,
Thank you, Your Honor.
you're welcome. And like I said, my condolences as well. I do believe, we already went over the guidelines. Did we go over the guidelines, or did you just request?
We did not, Your Honor, because I had an objection to OB2.
Okay, well, let me just ask Attorney Ryan then also, you did get a chance to review the pre-sentence investigation report and the sentencing information reports as well?
Your Honor, I have received the pre-sentence investigation report. I've had a chance to review them, and I have no objections or corrections.
All right. And Attorney Drake, obviously, then you got a chance to review them, and you do have something that you want the court to address?
I did, Your Honor, and I had an opportunity to go over that, the PSI with Mr. Suge and provide him a paper copy of it. I did want to object to the OB2, as indicated by the agent. In the video, all you can see is a, holster, which was presumably contains a firearm. But as he indicates, you can't tell if it's a firearm or pneumatic gun. If it was a pneumatic gun, it wouldn't be scorable under OB2, and there's absolutely no information in the record to confirm or deny that. The scoring still requires evidence at a at a preponderance level in order to score this. I think that there's some ancillary things to look at in the sense that there was no firearms charges originally associated with this file. I think that that's because, again, it's not clear, what's contained in the holster, whether it's a firearm or a pneumatic gun. Some of the airsoft guns look certainly realistic, but there's just absolutely nothing that can be pointed to confirm at a preponderance level that it was indeed a firearm. And I think that it would be inappropriate to use the fact that he has a CCW charge from 2022 because he was cooperative with the police when they came to search his residence. They didn't find any sort of firearms or anything there. So I just think that there's just not enough in the record to attach the 5 points that were scored on OB2. And would ask that it be scored 0.
Attorney Ryan, prosecutor's office, any position regarding OB2?
I was looking at the same scoring, and we discussed it prior to sentencing. I would indicate that I also reviewed the video. I suspect very strongly that it is a firearm. However, in the interest of being fair, I would indicate that just this week, I authorized a warrant where the police arrested somebody for carrying a firearm, and it turned out to be a pneumatic gun. Even the police were fooled by it until it was checked and confirmed. So I believe it probably was a firearm. Again, though, I can't really disagree with Mr. Drake about what the standard is for that particular offense variable. So we would leave it to the court's discretion. I would indicate, I think, that it would drop the bottom of his guidelines from 14 months to 12 months. If that adjustment were to be made, we'd leave it to the court's discretion.
And so your belief is that OB2 2 should be scored at 0 as opposed to 5. Attorney Grady.
Correct, Your Honor.
All right. Again, we'll go ahead and make that change. We'll go ahead and change OB 2 to 0. Did you have any other changes to the OBs or PRBs?
No, Your Honor, that was the only one.
That would drop the bottom line from 14 to 12. Would also drop the top end from 29 to 24 as well.
I believe that's correct.
All right. Mr. Suge, did you get a chance to review the information with your attorney?
Yes, Your Honor.
All right. Other than what he's pointed out, do you have any additions or corrections that you want to bring to the court's attention?
No, Your Honor.
Mr. Sugeman, before sentencing, I'm going to hear from the prosecutor's office, from Attorney Ronning. Then I'll give your attorney, Mr. Drake, an opportunity to allocate on your behalf, and I'll give you a chance to make a statement as well if you choose. Attorney Ronning.
Before I begin my allocution, I'd indicate for the record that the victim or victim's representative, Adam Pyatt, is here and wishes to address the court.
All right. Sir, just ask if you would please state your name and spell it so that we have it for the record, so I know who you are.
My name is Adam Pyatt, A-D-A-M-P-I-O-T.
Okay. All right. Go ahead, sir, if you want to make a statement.
Okay, good morning, Your Honor. Thank you for the opportunity to speak today. I represent the ownership and management of the farm that was the target of the armed robbery involving Mr. Suge. We come before the court today not only as victims of serious crime, but also as members of a team and a community that have been affected by Mr. Suge's actions. On the day of the robbery, Mr. Suge approached our facility armed with what appeared to be a handgun. We have pretty clear video of that. I'm sure our security team that now exists would be fooled by that and would take it pretty seriously in the event it was an air gun, so the consequence of it would probably be pretty similar. Surveillance footage captured him pointing the weapon through the fence in a threatening manner when he first enters the property, apparently ready to confront or intimidate anyone who might interfere. What's even more disturbing is this act of violence is not random, it was planned. We later discovered that Mr. Suge and possibly his associates had trespassed on our property and broken into the facility the day before the robbery. This speaks to the level of premeditation that should not be ignored in sentencing. Since that day, the emotional toll on our team has been significant. Several employees expressed fear and hesitation about coming to work, especially when working alone. This robbery did not just threaten our physical property, it disrupted our sense of safety and security. In response, we offered a $10,000 cash reward to help bring Mr. Suge to justice and have since hired armed security for all of our staff farm sites. These are not decisions we make lightly, but they reflect the seriousness of what we experienced. Your Honor, Mr. Suge has a known criminal history, including recent incarceration for similar offenses, yet here he is again undeterred. His actions on our property show a continued disregard for the law and the safety of others. We respectfully urge the court to consider not only the crime itself, but Mr. Suge's prior convictions and the likelihood he will reoffend. Our goal is to ensure that justice is served, not for our sake, or not just for our sake, but to protect the other potential victims and send a clear message that armed criminal behavior will be met with serious consequences. Thank you for your time and hearing my concerns.
Thank you, sir. Attorney Ronning, anything you want to say there?
Your Honor, yes. And I know the court is obviously aware, having reviewed the pre-sentence investigation report, this defendant has what can only be described as an incredible history of theft convictions. He's indicated that I believe there are 28 total convictions, 6 felonies, 22 misdemeanors. I counted 20 of those convictions are theft related, meaning Mr. Suge at 20 separate times, 20 separate offenses, decided somebody else's property belonged to him, or he didn't care whose property it was, he decided to just take it. And this is a lifelong issue. This is not a recent issue. This started when he was a juvenile. He's now 35 years old, and he's still stealing things that don't belong to him. He is on probation for stealing something that didn't belong to him, and he has a pending charge for stealing something that doesn't belong to him to go with these offenses. When this case initially came in, fortunately for him, lien did not show the Kentucky or Illinois or some of the Indiana convictions on our lien. Luckily, the Department of Corrections was able to find them. That's very likely would have affected how we resolved the case. He's on the E-grid because of what we thought was more of a minimal record. It looks like he probably belongs on the D-grid for a more serious offense. However, here we are. He has prison guidelines, or prison possible guidelines. I see the guidelines have been adjusted, and I respect that. However, I think the Department of Corrections recommendation that exceeded the original guidelines is still appropriate. When the Court of Appeals reviews these, as I know the court is aware, you look at to do a exceeding the guidelines, the court would look at the offender and the offense and the purposes of the sentence. And this defendant clearly will not be stopped unless he's incarcerated. His record, although horrendous, is actually underrepresented, I believe, in his criminal record score because he's maxed out. There are some offenses that don't even get counted because he's already maxed out on his prior low severity felony offenses. There's nothing about this case that would merit, in our opinion, anything less than either the top of the guidelines, and I would ask the court to consider exceeding the guidelines. I think a prison sentence is appropriate, and I think being a defendant for his behavior for the last number of years and minimal punishment over the last number of years, I think merits such a sentence. Thank you.
Ms. Smith, are you still on?
I am, Your Honor.
Okay, what's the status of the pending Branch County case? Has he ever been arrested, arraigned on that?
I do not have information on that. I can try to do a little bit of research if you give me a moment.
Because normally if they had, they'll put if there's a next hearing date or something that's scheduled, they'll normally indicate that in PSI.
Your Honor, while Ms. Smith looks, Mr. Suge does indicate that he has been arraigned on that charge, and he indicates that it was his understanding that that matter was being dropped.
Well, it looks like I can only access circuit court files in Branch County, so if it was arraigned at the district level and did not proceed, then I don't have that information available.
Okay, so you're not showing it's been waived up to circuit yet?
I did not see that it had waived up to circuit yet in Branch County.
All right then. Attorney Drake, then, anything else on behalf of Mr. Suge?
I would like to just point out some things that I think that are mutually agreeable regarding the facts of this matter. It's my understanding from the police report and from all the information that there was nobody present at the scene in terms of employees at the farm when Mr. Suge was there, and he was there for some time, so I don't want the court to think that, I know the term armed robbery was used, but it's my understanding there's absolutely nobody there. If you look at Mr. Suge's record, certainly, there's a lot to look at there, but other than the CCW charge, which comes along with the receiving, concealing, and stolen firearms, so, those two charges often, come together. There's no indication from his prior record. There's no armed robberies that I saw or anything to indicate that that is a part of the pattern of his behavior. I'd also like to indicate for the court that our sentencing structure set up by the legislature, the prior record score certainly impacts the guidelines, as the prosecution was indicating. And sometimes when lien doesn't show certain charges, you can have a low estimate at the beginning of the case only to have it raised up. And I bring that up because the prior record is part and parcel of the considerations that are baked into the guidelines. And disagreeing with what the guidelines say alone, should not be the basis for raising or going above those guidelines, even though I acknowledge that the guidelines are advisory and not mandatory. So his prior record has been considered, just like every defendant's prior record is considered. And as I indicated, to just say that we disagree, we think the guidelines should be higher, isn't an appropriate basis to exceed the guidelines. The Department of Corrections recommendations were for the top of the guidelines as it was previously scored. The guidelines have come down since then. I also think that it's worth mentioning, it's sort of paradoxical in the sense that although he has this record, when the police came to the house, he was cooperative with law enforcement. He made his admissions there at the scene when law enforcement came out to the house to retrieve the property. The property was retrieved and returned, to my understanding. He does indicate, or he even indicated at the time he had written an apology letter. That's part of the original file. For what it's worth, he does seem to, in that sense, be cooperative and did not, deny or try to avoid, his responsibility in this. I also think that it's a little strange because typically when you see a record like this, the theft charges are peppered with substance abuse charges or controlled substance charges, and I don't see any of that either. So I would say that Mr. Suge's prior record has been considered in the prior record score. It has impacted his guideline range significantly, as the prosecutor has indicated, and dissatisfaction with what the legislature presents to us as what they believe is appropriate guidelines. That alone should not be enough to exceed those guidelines. Frankly, given the fact that this was an offense that occurred when nobody else was around at the place, the fact that Mr. Suge admitted his responsibility at the time the police came out to his house, that he exhibited regret and remorse by writing an apology letter. All of those things, from my perspective, would earmark a lower gut sentence than the top of the guidelines. Other than the dismissal of the charges and the continuing pattern of criminal behavior that got scored on the OVs, there was no score for OB-19, and as I indicated, it's my understanding that the property was recovered and returned. So I would just ask the court to consider that a bottom of the guideline score would be appropriate in this matter. At the very least, I don't believe that there's anything in the record that would indicate exceeding the guidelines would be appropriate other than the prior record. And like I said, the prior record has already been calculated and baked into that guideline range. And dissatisfaction of that is something that, we can take up at the polling stations with their legislatures, but it's not appropriate grounds here within the courtroom to exceed the guideline range solely on our dissatisfaction with what they are. So I'd ask the court to consider a sentence at the bottom of the guideline range.
Well, and just before Attorney Rowney wants to interject or not, I think that the court can take into account prior records when we look at making a sentence as it relates to a particular defendant. Just because somebody has 4 or 5 high severity felonies, that getting to 75, if he's committed 20 more high severity felonies, the court, I think, can justify, as Attorney Rowney indicated, exceeding the guidelines, because we have to look at the defendant and not just the offense. So I understand where you're coming from. I understand where prosecutors coming from as well, because you have to look at the defendant and the offense. And so I understand his argument for exceeding, because even though the guidelines reach a maximum, as people continue to commit offenses, we can't say, well, we kind of ignore that because he's already reached the maximum. I understand the legislature sets them, but that's why I think the guidelines are advisory and that there is some discretion to give the court that ability. Not saying that I'm gonna, but I just understand we've got to look at
And
defense.
I apologize.
No, go ahead.
I was just addressing, I just want to make sure, and I think that it's human nature, I think that we're all guilty of it. Sometimes we look at the guidelines and think, whoa, that's way high, or whoa, that's way low. But I just want to, I think it's an easy thing to forget that under the case law, dissatisfaction with the guidelines in and of itself is not sufficient. And I was just making that point, Your Honor.
And I don't take any position one way or the other, whether you like them or not. They are what they are. All right. Mr. Suge, anything you want to say on your own behalf?
I just want to apologize to you guys. I'm sorry. I know what I did was wrong. It's not justifiable, anything like that. And I take responsibility for it. I apologize to you guys.
Well, a few things, I think, and you pointed out one thing, Attorney Gray, which kind of gave me cause when I looked at the criminal history, is that there aren't, a lot of drug convictions on here. So you wonder, why is he doing it? We see it a lot. We see a lot of thefts that happen as a result of people that have drug convictions. And then you think, but you don't see that with him. So is he just stealing just because? I mean, it doesn't seem to be an underlying reason, and somehow he's got to get himself past that. I also looked at, when I looked at his criminal history, and again, it's been pointed out, this is now, this would be his 30th offense when we add the 2 here. And when I also looked at, he committed 18 of these offenses. He committed 18 of those offenses while he was either on bond or on probation. So it was like, when we look at his status, it's like it didn't seem to matter. He was on bond on something, he was on probation status, and he just continued this, activity here. When I look at the case itself, specifically, Mr. Suge, and there's a lot of things, that kind of minimized. We don't know whether it was a gun or whether it wasn't. Maybe it was, I don't know. But you appeared at a location as well with a weapon, either something that was going to be used to scare somebody, or was in fact a weapon. And the mere fact that nobody was there and there was no confrontation, we don't know what might have happened had there been somebody there. There was some reason that he brought that. So, when you look at all that, you're lucky, because what would you have done? If it was a weapon and somebody confronted you, would you have shot? Would you be sitting in front of me today for murder? You're apologizing to me over something that's stealing property, and yet you put yourself in a situation. What would you have done if there had been a security guard there? Would you have done if someone had a weapon and pointed at you? Would you have fired? Would they have fired? Would you either be in front of me for murder or attempted murder, or would you be dead yourself? When you think about what you're doing in all these things, you may be dead yourself. You show up in a situation like that, you don't know what's going to happen. And so I just look at, I'm trying to understand why you're even doing it. And some people just, I guess, can't help themselves. Mr. Suge, in this matter, on December 14th of last year, approximately 2:45, you observed on surveillance video breaking into property at Penn Township on Shattuck Road in Vandalia. Stolen were 2 4-wheelers, a 12-foot trailer, a generator, power washer, some drills, and batteries. Concerning was that you were seen in the video armed with a handgun, or what appeared to be a handgun at the time as well. On January 12th, police did receive a tip from someone who recognized you from a wanted poster and said that you lived in Bronson, Michigan, specifically at 1081 Gibbs Road. When police went to the residence, they recognized the vehicle in the drive as the vehicle that was in the surveillance video, and they were met by a Thomas Willem, who gave them permission to search the barn on the property, where they found one of the stolen four-wheelers freshly painted, and the stolen trailer was outside. You were then located in the residence and admitted to the theft, told the officers where you disposed of the other stolen property, and my understanding is that all the stolen property was eventually recovered. Is that correct?
That is correct, Your Honor.
Okay. But there was some damage along with the fence that was at the property. I look, you're 35 years old and you have a criminal record now consisting of 30 convictions, dating back, as the prosecutor indicated, to when you were juvenile. You actually made a ward of the state in Indiana when you were 16. And from then on out, you've basically been non-stop. These are your 6 convictions for stealing motor vehicles. And you have a pending auto theft charge in Van Buren County. You have more probation violations than I can count on both hands. And like I said, when we look at 18 of these convictions or charges were while you were on probation or on bond, which means you'd already been arraigned and you had terms and conditions that were put in place by the courts. You know, you failed to appear in court at least 7 times. Again, you still have an outstanding warrant for your arrest for failing to appear in court in Elkhart County. By my count, it looks like you spent somewhere over approximately 5 years incarcerated over the years, in and out of jail and things. And when the probation agent states that he doesn't think you're a good candidate for community supervision, when I look at your history, that's an understatement to me. You know, you lie in the PSI when I read it when you say you've only tried alcohol, marijuana, and meth 1 time when you were 15 years old. Yet you pled guilty to an open container charge when you were an adult in St. Joe County, Michigan. So you only tried it when you were a juvenile, and now you're being convicted of an open container in St. Joe County, Michigan. Then you provided an apology letter stating, I can't say I'm sorry enough for what I've done, and I hope you can find it in your hearts to forgive me. How naive do you think we are, Mr. Suge? I'll bet you never coined an apology letter before or an apology to anybody else. As many times as you've been in court for theft, I'm sure you've apologized at least 30 times, or at least 20. I read a letter from the victim in this case, referred to the victim as a result of your actions. They had to increase the security at their farms, including armed security. At your age, you've shown you have no intention but to keep on in your criminal ways. And the only thing that I can see that you're truly sorry for is getting caught. Therefore, on count 2 and 3 charges of unlawful driving away of an automobile, since court on each count that you serve a term of incarceration in the state's prison from not less than 24 months to a maximum term not to exceed 12 years with credit for 12 days already served. Just pay $68 in minimum state costs on each count, crime victim rights assessment of $130, attorney fees amount of $350 to partially reimburse the cost of providing legal assistance in this matter, court costs amount of $500, which the court deems reasonable based on the average cost of prosecuting the case here in the county. And also order that you pay restitution in the amount of $2,347.43 for the benefit of victim R&H Investment Holdings. Also, in this manner, your driving privileges will be suspended if they've not already been by the Secretary of State as required under the rules and regulations. Sentences in these matters will run concurrently. Deputy there is going to provide you notice of your appellate right to review. You are entitled to file an application for leave to appeal. If you're financially unable to retain a lawyer, you may request the appointment of a lawyer to represent you in appeal. The request for a lawyer must be made within 42 days of today's date. Any bond in this matter is canceled. We'll deliver Mandy back to custody of Cass County Sheriff to be committed to Michigan Department of Corrections surveillance of your sentences. If you're really sorry, Mr. Suge, no court will see you back. That's just the reality of it. Because if I see you back and you apologize again, I'm going to tell you the same thing. Anything further from the people?
Nothing further, thank you.
Just one clarification, Your Honor. Did I mishear you say that it was 24 months to 12 years?
To 5 years.
5 years, okay.
If I did say 12, it's only 5. but-
I thought I heard 12 as well, so that's what I was asking.
Yeah, I just wanted to.
Oh, you know, I might have said that because I had changed the guideline range
Right.
that was in there, so I might have looked at where I had changed it to 12, but yeah, it would be,
All right, thank you, Your Honor.
5 years, yeah. All right. Anything further, Attorney Drake?
Nothing further, Your Honor.
All right. Mr. Suge, good luck. And again, I don't know if I stated as well, there will be credit for 12 days already as well.
Yes, Your Honor.
Credit for 12
Yep.
days.
Yeah, I thought that might have been with 12 cases on that.
Yeah, it might have been, but it's, and Attorney Kardowski.
Talked to him probably about 10 minutes ago, 15 minutes ago, said his GPS says 10:37.
Okay, there was a note saying he thought he'd be here about 10:30. Why don't we take a brief recess? I'll get some paperwork ready for the jail. I'll come back in on the 10 o'clock docket. And actually, I see Attorney Hogue. I thought we did have a 9:45 final settlement.
Mr. Warner, that's what we're discussing right now.
Okay,
He is
well,
here.
okay, why don't we go ahead and take a break? You can discuss with the prosecutor. We'll come back after we've done paperwork for the jail. We'll finish with that, and then hopefully by that time, Mr. Williams is on, will also be here.
Mr. Ward is on the screen.
Oh, okay.
We may need to talk about that one as well.
Yeah, there's some audio, I don't know. Mr. Ward, can you hear us now? You can't hear us?
He can obviously hear you. We can't hear you. Yeah.
We can have audio issues back and forth. There's a point, at one point on it, we could hear him, but now, I think it's on their end because I've switched devices multiple times, and we've also now, this is a different device, and it's still not being able to communicate, so.
And I guess the only way to do is check and make sure he's unmuted. He obviously can hear us because we see him responding when we're talking, but we can't hear him, so maybe they can check to unmute, or sometimes,
He can't hear us at all, Your Honor.
Pardon?
He can't hear us.
Okay, he looked like he was responding.
I think he just sees us talking, and that's about it.
Yeah, so, maybe they can sign off and sign back on. Sometimes that'll do it, so we'll take a short break.
It'll give us a chance to speak on his case anyways.
All right.
Thank you, Your Honor.
All rise.
Court's on recess, I'll call back.
Oh, okay.
Which one season PG? Okay. Yeah, we do not really. No, I don't think so. We should. For the record, you don't have to be here. Okay. No, yeah, I don't think there's anything. Okay, yeah. Yeah, that's it. All right, thanks a lot, Nick.
Yep.
I just want to know that there's something about record. Yeah. Oh, right, for Mikey, so for Mr. Christmas, you know. And Mike can show us next too.
So is this
It's like, it's about 10 minutes closer. I got something and then, yeah, absolutely. Yeah, and it's more transactional. jail visits and stuff like that. Yeah. Yeah. That like, for whatever reason. Yeah, right. Yeah, so it's less stressful. Yeah. Yeah, I'm just traveling for this for sure. I really like her more, but I like mostly.
I know.
But yeah, it's it was a little bit more rewarding though than I expected, to be honest. You end up helping some people that can't otherwise get it. It does, it really does. Yeah. Yeah. Yeah, absolutely. It can really, yeah, it can resolve cases. You can be a little more lenient or understanding where somebody's coming from.
Yeah.
And, yeah, I think that's a huge help. And you be a little more patient with the independence of their stuff, whether or not they want to take it clear or something. You got a lot of stuff usually going on. It's not like, for people that have been around the block a few times, it's more like transactional. It's like, okay, yeah, I know there's something to do with people that haven't had a whole lot of trouble, and they might be facing actually some kind of case of long time, see it right, and yeah, you're right. Yeah. Good job so far, but just started, so let's see. Yeah. And one of our paralegals is my son's got over here, so it's kind of so we're the family too. So that's cool. Yeah.
That's very cool.
Yeah. It is, yeah. Yeah, we're looking when we bought our house tomorrow, we 17, we're originally looking at South Haven. And we just barely.
Are you able to hear us now, Mr. Ward?
But it just wasn't enough space, and so we were just gonna leave, retire space and stuff. And now it's like, there's no way we have to be looking at South Haven.
No.
Yeah. Really? Oh, nice. Yeah. Yeah, about 20 years ago, there was I don't know what it was, sailing event, but something like the tall ships sailing event, so we had 100 of those things coming in the water, and then that brought in a whole bunch of tourists, so this thing and was like, we commissioned, get you filmed, do a small camp here at the Maryland Museum, so, yeah, like, I don't know, it was 2000 when that event happened, and that boat is called the French Steering Wheel. I think we've had this on it for about 20 years. Yeah. Yeah, so you see that big old, like, pirate ship in the harbor all the time when the goes out. Oh, yeah. And this is a small one, too. It is huge. Yeah. 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 Oh, really?
So we usually give her space until she'll finally eventually say, okay, I got out there, I can leave it. So much done. She has this right form that it's her private session. She has to bring over or everything. Social Security, and so you can't get so so they leave, I call back with another guy, I comes back with the supervisor. Leave it, tell him, how do you do that? Because I would go to Greg, just like have one of them come down and house. And she raised my work, so and I work all the time. I work, you know, some of his husband is a, I would like to get a work out for me. So if she goes bad, she got caught in one more, and she got that's what her confidence when you leave her house, so she parks there. And she, and so they're trying to have her and she was on the little things. And they it's just another story. So eventually they had to process that they lose not so bad, but they went on my current for her to let them leave. She's not an imposing figure at all. She kind of like my boy tall, probably weighs like 100 pounds at that, you know. And here she dresses like so it's all like numbers of the baby. It's like pants that she like cinches off the side of her. So me and my siblings were just like, she was telling us a story, we're just like, sure, you can just see her on there riding awful and walking them in. Poor dude just totally had no idea that he never experienced anything. They would probably like call people, she won't let us leave. Well, and she does, like, you know, her weapon has always been an enormous attitude. All honest. She is, my kids told the story when they were really young. She speeds all over. She doesn't drive like that on the house. She has a bunch of recordings she don't drive. She had full house of her street. And then when the cop came out, she was like, what? So sorry, so scared. Like this would tell us all the time. No, we went to Subway and Grandma screamed at the Subway. Excuse me. Yeah. I love it.
I told him, tell me the story that was your report. Yeah. His mom came out. Gentleman in that his professional place.
I'm ready to roll. We gotta go.
Yes, father.
I will talk with them.
Really? That's awesome. Yeah. You know, that's very cool. Very
So, I think we should. I had a degree here to work, but I got to go to jail today and tell this what's going on in your trial. You got it. Now that you have it. Right, yeah, I tell him the court.
Okay, this guy falls in the judgment, I didn't throw that on the board, he stands.
All right, sounds good. All right, I appreciate it. I'm glad that you asked though, because I feel bad about that.
What did she tell him?
And you used to look at someone's door.
Yeah.
You can't believe it.
You're right.
And
Put it down there. Just over stupid place.
I don't think so.
And the people who like, hey, the police officers and the prosecutors who were behind, they didn't want to join because we had to lose. You know why? You really don't play. Like, it's like, we don't care. And it feels like, come on, we're going to go.
Instead of bringing it to the store, he said, patio.
Yeah, right.
He called and said, oh.
Like 30 to 25. They said, you know, it's like,
I had to take a meal back.
yeah.
And I was like,
Yeah. Yeah.
So we gotta go, Mom, get down in. Someone's there. No, I'm gonna stop that house. I'll leave it out and see.
Yeah.
So Julie went up to the car, and got a can of our usual drink. And keep it calm, guys, down here in Canada, that's what it is. So, they'll mail their tickets.
Yeah.
He showed a copy. Joe got two off the Joe, and he got the other ones off with, Jessica. And said, oh, you gotta do it, come whenever you want, I don't care. But I ain't gonna do this again. Because Julie put a plan on. I know who my family
You're supposed to be a commercial real estate.
Yeah. So, that's you, that's,
From Heights.
Joe's on
Yeah. Oh, couldn't move along.
Yeah. Another job, so I feel bad, you know, just
For sure you'd be heartbroken. Who do I talk to about seeing your sister? When I see you, I'm fantastic.
Fantastic when I see you too.
Thank you. This is Swansea back here. He's now.
Oh, yeah?
Well, we'll walk from the other. Okay. Thank you.
Yeah. It's funny, because I worked with, without the returning back from some attorneys that I, can't remember, like not knowing what. Yeah. Yeah, like my dad, had some, like, prosecutor interns when I was like 5 years old or whatever, and now they're, in their 60s and stuff like that.
Oh, yeah.
It's just funny, but it's ordinary thing, you know. Bring one of your pretty girlfriends to my parents' house and turn it into my party. Yeah. Right.
There's some with you?
Oh, no, I had a final pre-trial with Ken.
Yeah, but he's not here.
Yeah, no, yeah. I don't think there's something on the record, but. What kind of, is that a service road?
That's one of the services.
Okay. We had those at IDSOs and we have like the cheaper version and stuff, but that one was like.
I like it. I need one of those pen things. Right?
Yeah.
I like it.
Oh, Ken is here. Hey, Ken.
All right, take care.
Jason, good morning.
Good morning.
Oh, there's Ken.
Nick, on the trial for next week, I'll let you know for sure by 1.
Okay. Sounds good. Who's going next week?
Nobody probably. I thought we were living up.
Good morning, Dan.
Good morning.
Hey, Ken. Hey, good morning, Greg. Either board, didn't see you there, Greg. It's okay. Are you okay to take the trial on Tuesday?
Is that, you had 2, right? Isn't that, you had an BG one?
Nope. That's what it's.
Mine was.
I was on it. What's today? I want to get this clear this morning.
Who's that?
Morning, Marie.
Good morning, Ken. Zach Smith was just here, Ken.
Do you know what Kate Snack was there for?
Yeah.
I don't, but he said there's no resolution.
Okay, because I didn't see anything on the docket for him today.
Right. Well, you know, they put the final pre-trials on one docket, but not on the ones we're actually going to hear.
Right, good point.
Okay?
Yeah, I was looking for today's, like you mentioned, I was looking at today's document. Like you mentioned, I didn't see it, so.
Okay.
I'll give him a call.
Okay, thank you.
Thank you.
Still on?
Said 10:30, said 12 minutes.
12 minutes, he's got 4 minutes.
37.
Oh, is that his?
Break it.
Last I heard it was 10:30. And I can't do that. But I know what time we are. If they're 5 minutes early, wait for 2 hours. What's that remind you?
I hate this stuff so bad. We're gonna be at the rifle range at 0600.
We don't know how
So,
now.
we're gonna be there at 0400. I'm like, why? You know, and the thing is, the funny is, I was on a book somewhere. It's like the generals say they're 0800, right? The generals tell like, EAs or whatever, hey, get everybody mustered at, they have everybody there, they tell their guys,
07.
07. And then those the staff sergeants are telling the sergeants, all right, now you guys will be 06. And then it goes down to the sergeants, and it just keeps adding. Everything
Goes the wrong way, no matter what. And Nick, Mr. Trulo's in jail.
Okay. Did you want to call Christian Ward then?
No.
Okay.
And then, I think on Zemansky, did, Mr. LeBray talk to you?
You said he was going to get on to speak with him?
Yeah, but he's over, I think he's going over to talk, so I think we're gonna have it. Leave, I don't.
Hey, Greg,
Sir?
Oh.
what did you mention that Christian Ward?
We're not calling it today. We don't have an agreement yet. I'm working on it for you.
Okay.
And Mr. Roden just picked up new charges, so.
Yeah,
What
and
do you
you did on, for a motion to revoke bond on the other one.
Denied.
So maybe we do need to have Roden on. Do you have a motion filed?
No.
Okay.
I'll bring it up orally and see what the judge says, and.
That's fine.
If he wants me to file a motion, I'll file a motion.
No, I'll step to do it today.
All right, I appreciate that, Mr. Feldman. Ward, I think, just on that, the other one, Christian Ward, not Terrell, that's another one, so I have to make sure. I may have, we may want to discuss it a little further.
He's coming in next week to view video. My video link expired, so, and Scott's not in today. So he's coming in like Wednesday to watch video with me.
Excellent.
So can we talk maybe Monday or Wednesday?
We can talk anytime you're available, Greg.
Well, I'm here, Ken.
I know that.
That's just a subtlety.
Vincent is the only trial left for next week.
And we're all set for next week on that other matter, am I correct? Is that scheduled for Monday on, don't tell me. On True Love?
We're doing it this morning.
Oh, okay, excellent. I
That's
did not
fine.
realize that.
No problem. I'm taking care of you, Ken. I got your back.
I appreciate that. Just also send me money when you get a chance.
Do you want me to have your office send you the file?
Of course.
You're always so accommodating, Brent.
Always.
Waste. And it's never fine.
It's never plans that have it's the cases where they admit every
years. I actually had one yesterday. My client had the security camera, case dismissed.
Yeah. I thought we
Came up behind the car, socked the guy through the window, and he either opened the door and pushed her down, or the door pushed her down so he could leave. He goes credit case and said, I'm done with this. She broke the collarbone. She probably broke the collarbone in the car door when she swung in. My brother is up in Mackinac, and I gave him one of my old bikes. It's a nice road bike, actually. And he put some thicker tires on it, and maybe I geared it a little better. He's been taking it everywhere. He goes to ride. And I guess he was riding back from the ferry. I don't go to Mackinac. I'm not Mackinac.
I've never been, we're actually going on the second week of June, we're going to have leadership training conference over there.
So he gets off the ferry, and his wife is off doing some corporate thing, and he's riding back on the same trail he rode to the ferry, a couple hours earlier, and he didn't realize there was a drop, and so it's kind of like semi-dark. So he goes up the drop, it shakes on him. Tire probably a little crooked, so he ended up broke his car around, commuted in 2 places. Ooh, that's so great.
I broke my collarbone as a young kid.
Played soccer?
Car accident.
Ooh.
My first car accident.
Is the statue running that?
We were, actually, but it was just like, it was back before you had seatbelt laws.
Right? Right. So he's bummed, he's a big time golfer, pickleball, and even though those, he did it last night, so he calls me this morning, and he's a real big guy. He's like, hey Jeff, how you doing? He goes, hey Greg, and I'm like, what's wrong? He goes, I broke my collarbone. I said, is my bike okay? And I hear his wife just start busting a gut in the background, your bike's fine. Your helmet's really scraped up, but your bike's okay.
That's such like a 12-year-old thing to say.
It's a brother thing to say, you're doing my bike. I go, I'm completing a golf league in here. Or, I think, is the collarbone most broken bone in the body?
Surprise me.
Dr. Google? Is the collarbone the most broken bone in the body?
Wait a minute. The one yesterday?
Oh, well, that's how it came up.
That's how you're talking.
Yeah, and I thought yesterday, I wonder if she broke it, swinging at it. I mean, it's possible, Jason, but... No?
It's possible.
Do you understand my brother broke his yesterday?
Oh,
In
no.
2 places, a bike accident up on Mackinac.
You fall?
Oh, he did what we call an endo.
It is that.
He went,
Head over.
I gotta show you guys a picture.
That's what they're doing.
So we're coming down, what's the road, comes out of Niles, heads out towards 60, where there used to be Eastgate and JCPenney, it's the medical offices now.
Yeah.
Yankee? Yankee coming out?
In terms of Oak Street or Wallen, so I'm not sure.
And I had stopped before we got really kind of cooking, because I had to relieve myself. And so I caught up with the lead dog. I kind of sped past the other guys and caught up with the lead dog. And he and I are out front. He's got these cool sunglasses that have a little mirror, really can't even tell. Up here. These ones are.
There's nothing cool about them.
He can see back behind, so I'm like, how far back are you? He's like, about 40 yards. So I'm like, let's just go to 60. So we just get a tempo of 160, and I'm talking to him. We get to the light, and the other 3 guys come up behind us. And one guy goes, man, I was sure you were down. I'm sure you bet. The other guy goes, yeah, I don't know what happened. He stood up to try to catch us, to go into a sprint, and his clip popped out. And so his other one popped out. And so he went down onto his bar and had both feet flat on the ground, sparking as they went along. And that's what his shoe looked like when he got done. That's all gravel. That's carbon fiber, so that's all. That's all jacked up. So,
Please be seated. We'll go back on record on the court's morning docket on Friday, May 30th. And Attorney Kardowski, we got Mr. Williams. We'll go on record in file 25-10043FH, People State of Michigan versus Tommy Ludellian Williams, and you're Mr. Williams, is that correct?
Correct.
All right, and Mr. Williams is in court represented by Attorney Robert Kardowski and the Prosecutor's Office, Assistant Prosecutor Attorney Lisa Ryan. This matter is on the court's docket for sentencing today on a charge of unlawful driving away of a motor vehicle, and for purposes of the sentencing, the court received and reviewed the pre-sentence investigation report and the sentencing information report prepared by Agent Browning. Attorney Browning, did you get a chance to review that information?
I had a chance to review the pre-sentence investigation report and have no objections or corrections.
All right, and Attorney Kardowski, you got a chance to review the report? We'll
Received a copy of the report, provided a copy to Mr. Williams. We have no additions or corrections.
Is that correct, Mr. Williams? You had a chance to go over the information with your attorney?
Correct.
And did you have any additions or corrections you wanted to make?
No.
Okay. I will give you a chance to make a statement if you choose. First, I'm going to hear from the prosecutor's office, Attorney Ronning, then I'll hear from Attorney Kardowski on your behalf, and then I'll give you a chance to make a statement if you choose. Attorney Ronning.
Your Honor, reviewing the pre-sentence investigation report here, and then when this offense first happened, I remember one of the things that really stuck out was, I believe this offense occurred barely 1 month after the defendant's 18th birthday. So he'd be, we've had a number of defendants like this in the last year, but just turns 18 and then is committing a felony. He does have an incredible opportunity here. The court had indicated initially that there would, was a COPS agreement that he would be sentenced under the Homes Youthful Training Act. We understand that given the defendant's age, I want to make sure the defendant understands how fortunate he is that he's eligible for that the court is willing to consider it. And I think that the context of today really helps that the court sentenced somebody to prison for stealing motor vehicles today, just at the last sentencing, so that the defendant is aware that this time he's going to be able to maybe take advantage of this program, but continuing to do that type of behavior will end up in prison. There are co-defendants in this case, both of which have worse criminal records. This defendant apparently has zero criminal record or zero criminal involvement. He was what we believe to be the passenger in this truck that was on an incredibly dangerous chase over 30 miles, over 100 miles an hour into an entirely different county. Fortunately, nobody was hurt. Fortunately, there was only a little bit of restitution being requested, no real damage. Again, nobody was injured. The officers are not injured. The defendant is incredibly lucky. I hope he recognizes that and takes advantage of his opportunity.
Thank you. Attorney Kardasky.
Your Honor, as indicated by the prosecutor, Mr. Williams had just turned 18 right before this incident occurred. He has no convictions for anything. It tells you that he's still in school. He's attending Comstock school system, or it's not Comstock school system, but Comstock High School up in Kalamazoo. He has one more semester remaining to graduate. He understands that this was a very foolish thing to do, and also that riding in that car when the co-defendant took off like that, he could have killed both of them. He still wants to go to college, and we are asking the court to honor the COPS agreement.
All right. Mr. Williams, anything you want to say to the court before sentencing?
No.
Okay. Well, Mr. Williams, on February 11th of this year, approximately 5 a.m., police were dispatched to a stolen vehicle complaint that occurred in Howard Township on Thunderbird Lane. The owner had a tracking device in the vehicle, and the deputy almost immediately got behind the vehicle on M51 near Pokagon Highway, activated lights and sirens, at which point the vehicle accelerated going north on M51 to over 100 miles an hour. The vehicle then did a U-turn in the parking lot and headed south back on M51, again accelerating to over 100 miles per hour. The vehicle then turned east on Burton Road, spun out, and headed back onto M51, again turned north, accelerating to over 100 miles an hour, and then turned onto Indian Lake Road. At that point, Marion County Sheriff's Department then deployed stop sticks on M140, and eventually the vehicle stopped, and you and the other individual were arrested. As has been alluded to here, you're just 18 years old. You're still in high school, and you have no prior record of any kind. And I don't know what you were thinking in this whole situation, why you got yourself involved with it. But again, I think it's pointed out by the prosecutor, you could have been killed. Someone else could have been killed in this situation, or both. And what a waste that would be at your age. You could have been killed if there had been an accident. If someone else had gotten killed in this situation, realize the prosecutor could be charging you as an aider and abettor to a homicide with a vehicle. You could be looking at going to prison, because the guidelines on those on a death would be, even as a first offense, would probably warrant a prison sentence. So that's kind of where you are. So yeah, you need to realize the one thing that concerns me is while you were a passenger, I do note that in the police report that you had a key fob on you, which also belonged to a stolen Subaru. So I can't look at this and say that you were a totally innocent participant in the whole situation. And that's why if someone had gotten killed, the prosecutor might be looking at charging you with murder. And so, you know, that's where you got yourself in a situation into. I do note that the other thing I want to let you know is, and I see it all the time, you're never going to outrun the cops for two reasons. Number one, their vehicles are normally faster than any vehicle you can steal, because that's the way they're made. And if you keep running, just like in this case, more agencies are going to get involved. So when you cross into Berrien County is going to get involved. The Pokagons might get involved. The Berrien County Sheriff's Department, the Cass County Sheriff's Department, the what? So every time when you're involved in a situation like this, you can't run from them, because as you run, there's just more and more people that are going to be coming after you. So you get yourself in that situation where you could have killed yourself, someone got killed, you're not going to get away. It's just a lose-lose proposition. And why, when I look at you, you know, I know at the PSI you enrolled in the Comstock Compass program, but I note that your attendance has been sporadic. I know this is your first conviction of any kind. There was an agreement at the time of the plea to be placed under supervision under HIDA, and that was an agreement that the court also agreed to. That gives you the opportunity to have this matter off your criminal record and comply with your probation and the terms and conditions. How if you're unsuccessful and violate your probation, this could go on your permanent record, and then you could also be back before the court facing some jail time just on this. And as the prosecutor pointed out, we had an individual that just before you, if you'd been here earlier, you'd seen he went to prison for auto theft, and it wasn't his first. He had a number of them, but he eventually realized that if you're involved in these in this kind of activity, that's what can happen. Also, at your age, you don't appreciate, I don't think young people appreciate, I hope you listen to me. Are you his mother?
Yes.
Okay. I hope you talk long and hard at him, and you probably have too, is that you don't realize that something you do at your age can affect you for the rest of your life. When you get that felony conviction on your record, I hear that you want to go to college. What do you want to be when you grow up? When you go to college, what do you want to do?
Entrepreneur.
Okay, so you want to have your own business? Okay, do you understand that with a felony in your record, there are a lot of business licenses that you cannot get? The state has bars, requires that you not have criminal convictions on your record. So if you want to have a business, realize just anything, not just stealing cars, any criminal conviction can affect your ability to do that. And I don't think kids appreciate, they go, oh, I did, I'm young, I'm stupid, I did something foolish. But that can affect you forever. And so I hope you appreciate the opportunity you're getting, and you do take it seriously, because it can come back to haunt you, and you can I know people that went to law school and found out that they couldn't pass the character and fitness because they had a conviction on their record. And so, I mean, it happens, and I hope you appreciate it. Like I said, I noticed that your attendance was sporadic. I hope you're serious, that you do complete the program, and that you do go on to college. Because trust me, if you go on to college, if you go to high school, get your college, get your high school diploma, go to college and get your college degree, you know what? You can buy any car you want. You get a business, you can buy any car you want. You don't have to steal somebody else's car. What'll happen maybe someday is that you're a business owner and you have a car and someone steals your car. And then you're going to be sitting in a court as a victim going, hang him to the highest tree. He stole my car. Think how you'd feel if you had a car and someone stole it. Or a motorcycle. Or anything. That'd probably make you pretty mad, wouldn't it? So, again, I hope you appreciate what you got here today. And I hope you think about, how you'd feel in those same situations. And, the opportunity is something that you need to take seriously, and hopefully if you do, you'll go on and have a good life. And I'm sure mom's talking long and hard at you. You also got to look out who you hang out with in life, And again, I think it's hard at your age as well, as to people that are friends at your age. As you get older, you realize they weren't really friends. They're dragging you down the wrong path. And you'll learn that when you get older in life a little more. But you think people are fun and you like hanging out with them. But if, when they drag you down, they don't care. What a true friend does, a true friend supports you. A true friend wants to see you succeed. A true friend wants to support you when you go to college. A true friend wants to see you be an entrepreneur and have a business. A true friend doesn't want to do all the things that will keep you from attaining what you want to be in life. And I know at your age it's probably hard to appreciate it and see it, but it's true. Just don't let people drag you down, okay? So what I'm gonna do is, on that count one charge, on unlawful driving away of an automobile, I will assign you to the Homes Youthful Training status under the Homes Youthful Training Act, under the authority granted to the court under Michigan Compiled Law 762.11, and place you on probation for a period of 2 years under standard terms and conditions outlined in the pre-sentence investigation report. In order to pay a supervision fee of $720 at the rate directed by your probation agent. In order to serve 3 days in Cass County Jail with credit for the 3 days you've already served. Also, that order to undergo substance abuse and a mental health assessment is directed by your agent, completing the recommended services or program. In order to complete the Stock Compass program or other educational program is approved by your agent. In addition, there will be a $68 minimum state cost assessed, a crime victim rights assessment of $130, a fine of $500, and court costs of $500, which the court deems reasonable based on the average cost of prosecuting a case here in the county, and in order to comply with DNA testing and pay the associated fee. I did have a restitution request that I didn't have until today. It was for $1,350, which includes the deductible and some of the lost items in the vehicle. Attorney Ronnie, are you asking that the court impose this as restitution this matter?
Yes, Your Honor, we'd ask the court to order $1,350.
And Attorney Kardowski, did you get a chance to review that and go over with Mr. Williams?
Did provide a copy to Mr. Williams, and we had no objection to it, just asked that it be joint and several with the code.
Right. And what I'm going to do then, I will order restitution this amount in the amount of $1,350. That'll be joint and several. And what that means, so that you understand it, and maybe Attorney Kardowski talked to or did. Joint and several means that when you're involved in a situation with somebody that you're all liable for it, so the other individual's liable for it too. But if he never pays it, you can end up paying the whole amount. And so in the future, if you're involved in criminal activity with somebody else, realize that if something's damaged or stolen or taken, you can end up having to pay for all the wax. So normally what happens a lot of times is that both people end up paying, half of it. And so that's kind of probably what you're looking at. But if something were to happen and he never pays it, they can keep collecting from you. So realize too, when you're involved in something like this, it gets awful expensive too. You already spent a couple days in jail. I'm sure you didn't like that, right? Right. And realize that you could spend a whole lot more. Even in this situation, as a first offense, I think your guidelines, was it up to 6 months, up to 9 months? You could end up doing up to 9 months in jail over this, even just as a first offense. So think about all those things. You're young. You got a good long life ahead of you. Don't throw away. Be what you want to be in life. You got that opportunity. And we're giving you a heck of an opportunity here to have the matter off your record. And I hope you're serious about it and that you take the opportunity to do that. And that you go on and have a happy life. Buy your own, don't give your money to me, not me personally, but to the court. Don't give your fines and costs and everything to the court. Think of the money that you have to pay and the restitution you have to pay. That's a heck of a good down payment on a car for you, isn't it? Maybe even a car for you. And instead you don't have the car and you're paying all that money. But like I said, if you do things the right way, buy your own car. Whatever one you want. Okay? So again, give you an opportunity. I'm going to advise you to have the right to appeal your sentence or conviction. Mr. Williams, we'll have the bay up there provide you with notice of your trial right to review. That just indicates that you do have the right to appeal your sentence or conviction here today. You can do so by filing an application for leave to appeal. If you're financially unable to retain an attorney and wanted to have an attorney appointed to represent you, you could fill one of those forms out that you'll receive completely, return to the court within 42 days of today's date. I would review that and qualify to appoint an attorney to represent you. Okay? What I'm going to need you to do, Mr. Williams, after we adjourn sentencing here today, you'll need to do two things. You need to contact the probation department or go to the probation department to set up to go over your terms and conditions of your probation. And then before you leave the courthouse today, you need to go to the clerk's office, give them your name, phone number, address, those kinds of things, and make payment arrangements on your phone. Okay? All right. Anything further from the people?
No, Your Honor, thank you.
Okay.
Further down.
Mr. Williams, any questions for the court? No. Sir, please don't throw your life away. You're so young. Move forward in life, okay? Impossible. So go ahead and adjourn. Let's see, my understanding is Mr. Ward's off because of the problems we have. Is he back on, or?
Well, at this point, we can't communicate, Your Honor, so it's, I know we've tried that multiple times with different devices, but we can't get through.
All right. And, Mr. Ward, you can't hear us? Yeah, here's okay. We'll go ahead then, I guess, and reschedule him. And I guess worst case scenario, I don't know if we can check if we can't get through to him. I suppose maybe next time they could call in, we could actually put him on a telecom, and
Even better, just rid him in physically.
and then we could at least have some audio. Do you have Mr. Warner?
I do, Your Honor, he's in the courtroom.
All right, Mr. Warner? All right, Mr. Warner.
Your Honor, I do have his advice of rights when they approach.
Absolutely, appreciate that. Saves me. I'm getting tired of listening to me. I didn't hear you, so unless I have to talk. We'll go on record, file 25-10024 FH, People Davidson versus Nathaniel Rod Warner. And Mr. Warner. Mr. Warner, your case on my docket here today for final settlement conference, but I do have the advice of rights that was presented to me by your attorney, Mr. Hogue, who's here on your behalf, and then on behalf of the prosecutor's office, Assistant Prosecutor Jason Ryan. With the receipt of the advice of rights, I'm assuming there's a plea agreement. I do have an amended felony information. It was filed obviously on April 2nd, so if we're working off that, let me know, Attorney Ryan, and what the agreement is.
Thank you, Your Honor. It's the people's understanding that the defendant will be pleading guilty to the added count 4 in the amended felony information. Pursuant to agreement, people will dismiss the remaining counts. I don't believe there's any habitual offender notices. If there were, we would agree to dismiss those as well.
There's not on the amended.
Yeah, I was seeing that.
I'll just check the original too, make sure they're not on file. Yeah, there was not on the original.
So we'd just be dismissing the remainder of the counts. So we're just pleading to one count from larceny from the person.
All right. And Attorney Hogue.
Your Honor, that was a correct statement of the offer. I discussed that with my client. My client intends to accept that offer today.
All right. Can you raise your right hand, Mr. Warner? Do you solemnly swear or affirm under penalties of perjury that the testimony you will give in this matter now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Put your hand down. Now, is your name Nathaniel Robert Warner?
Correct.
Okay, and Mr. Warner, what is your date of birth?
5/23/96.
Now, if I accept your plea here today, you understand that you are giving up the right to have a trial, and that includes the right to have a trial by a jury.
I understand. Right.
And I do have your advice of rights sheet here that Attorney Hogue gave me. You had a chance to review that and go over it with Attorney Hogue?
Yes.
Ask him any questions regarding those rights that you're giving up by pleading here today. Do you understand all those rights, and did Attorney Hogue explain it to you, or did you have any questions?
I understand.
Okay, all right. In addition to those rights here that you're going to be giving up, I want you to understand as well that you are giving up your appellate right to When you do plead guilty, you give up certain appellate rights, and that includes when you have a trial, you can appeal your convictions called as a right. But when you enter a plea, you can still appeal, but it requires the filing of an application for leave to appeal. And the issues you can appeal on are limited. So do you understand you are giving up some of your appellate rights?
I understand.
And then in addition, you're giving up the right to later come back and ask that I set aside your plea because of a promise or threats that have been made to you that you've not told me about here on the record. Prosecutor Rowning just indicated that you pleaded guilty to that count 4 charge of larceny from a person, and your attorney confirmed that, and is that your understanding of the agreement?
Yes.
Okay. Other than that agreement, has anybody promised you anything?
No.
Anybody threatening you in any way to get you cleared yet?
No.
Are you pleading guilty to that larceny from a person charge because you believe you're guilty of that charge?
Yes.
I want you to understand as well that that charge is a felony in the state of Michigan that does carry a maximum penalty of up to 10 years incarceration. Do you understand that?
Yes.
And understanding that you still wish to enter your plea here today?
Yes.
Okay. Now, that charge reads as follows, Mr. Warner, on or about January 16th of this year, that you did in the city of Dowagiac here in Cass County commit the offense of larceny by stealing from the person of another to a Darrell Palmatier certain property to a BB gun contrary to Michigan statute. You understand that charge?
Yes.
Okay. I'm going to ask you some questions, take you back to January 16th. Were you here in Cass County in the city of Dowagiac on or about January 16th?
Yes.
And I show up that time, and do you still live at the 204 Hill Street?
Yeah.
Okay. And where did this incident happen?
At Tractor Supply Company in Wallen.
Okay, so just outside by what used to be the open mine is now the nitro zone, that one there?
Yeah.
Okay. And tell me in your own words what happened.
Well, I went there to, I knew what I was going there to do. I don't know, it's not really my character, but it's just a bad period of my life, I suppose. I can't think of a reason why. But
So, yeah, what'd you do?
I went there and I put the merchandise in my jacket, and when I went to leave, the buzzer went off, and Mr. Palmatier told me to come here, and I gave him one of the items, but not all of them, and he said to give him the rest of the items, and I told him they were done, and he said that he would have the police come and search me then if need be, and at that point I just tried to leave, and the other gentleman grabbed me, and then I just kind of started really trying to leave.
So who is Mr. Palmatier? Is he working at TSC did you take the items from him? Is that what happened?
No, the item I took was from the shelf.
Okay.
I don't know what.
And you said you had some other items as well? You took a number of items?
Yeah, three items.
Okay. And so, and was one of them a BB gun?
Yeah.
Okay. And, all right. Then Mr. Palmatier said, get it back. You said, I only had one item, and then you had, and then eventually you tried to get away at that point.
Yeah.
Okay. You satisfied, Attorney Ryan?
Yes, Your Honor.
Yeah, Attorney Hope?
Yes, Your Honor.
All right. Let me ask you then, Mr. Warner, then as to that charge, count 3 charge in honor about, count 4 charge on about January 16th, 2025 in the city of Dowagiac here in Cass County, that you did commit the offense of larceny by stealing from another person to it, Darrell Palmatier, and certain property to a BB gun, contrary to Michigan statute. How do you plead to that charge?
Guilty.
All right. I will go ahead and accept your plea, find it is voluntarily and understandably made, and it's made with the assistance of your attorney. There's sufficient factual and jurisdictional basis I'm going to set your case for sentencing on Friday, June 27th at 8:30 in the morning. In the meantime, what you're going to need to do is contact the probation department, and they're at 445-4404, or you can go there immediately following sentencing or they contact them. They will do a pre-sentence investigation interview. They'll prepare a report. You'll have a chance to review that report prior to sentencing with your attorney, as well as the prosecutor. Court will review that. And then just make sure you do that as soon as possible, because that report needs to be prepared before we proceed with sentencing. Also want to advise you as well, the prosecutor gave you a plea agreement here. You need to understand that between now and sentencing, that if you commit any violations of law, including violations of your bond, those kinds of things, that this agreement can be revoked, and then you could go to trial on the more serious charges. You understand that? Yeah. Okay, so with that then, anything further from the people?
No, Your Honor.
Thank you. Attorney Hogan, anything further?
Nothing else, Your Honor. Thank you.
Mr. Warner, what is the phone number? Normally we wouldn't call you, but we would in case of an emergency. If something, was happening, most of the time, Attorney Hogan contacts you, but if we need to give it, what's the phone number?
It's 269-487, 6321.
6321. Make sure you call, contact probation department, okay?
Okay.
All right. Anything further?
No, Your Honor. Thank you.
Attorney Hogan?
Nothing else, Your Honor.
Any questions for the court, Mr. Warner?
No, thank you.
All right.
Nick, I'll send you an email about that adjustment on that one.
Attorney Feldman?
Good morning again, Your Honor.
Good morning.
Mr. Trulove in jail. He'll offer a plea for you.
Okay. Do we have anything with, on Mr. with Gray?
He was here.
There's some confusion about that. I think Mr. LeBray went to go talk to his client, and he may have, I think, assumed that the plea was going to have to be rescheduled because he needed to go talk to him. And I sent him a text saying if he came back, we can still do it today, but I haven't heard back. He may be in the jail.
Who is this?
Mr. Trulove.
That's Mr. Trulove.
Okay.
Mr. Szymanski is Mr. LeBray's client. They're probably meeting right now. So.
Oh, am I still showing up on the calendar for Mr. Szymanski?
No, I just was...
Okay. Mr. LeBray replaced me. I'm going to do it this afternoon.
If we can get it done in time, then that's fine.
I'm going to check with Rock and see if he wants to do them early. Rock might try to do them early.
So that's why I got to put it together. Yeah, right now.
And is this Daniel?
Yes.
Okay. All right. We'll go on record then and file 25-10001 FH for the state of Michigan versus Daniel Christopher Trulove. Are you Mr. Trulove?
Yes, sir, I am.
All right. Mr. Trulove, your attorney, Mr. Feldman, is present here in the courtroom on your behalf. And then from the prosecutor's office is Assistant Prosecuting Attorney Ken Stecker. Mr. Stecker, see you there on Zoom. Can you hear me all right?
Again, Your Honor, and good morning to you.
Good morning. We do have, in this matter, it looks like we have a jury trial scheduled next Tuesday.
We do, but we offer a plea here this morning, Your Honor.
All right. If there is a plea, Attorney Stecker, if you could please state that agreement for the record. I'll confirm that with Attorney Feldman, and then Mr. Trulove, I want you to listen to the agreement. I'm going to confirm those terms and conditions with you as well, okay?
Okay, yes, sir.
All right, Attorney Stecker.
Your Honor, I will graciously allow Mr. Feldman to put the plea on the record.
All right, Attorney Feldman.
Thank you, Your Honor. Mr. Trulove tenders a plea of guilty to the count 1 charge, possession of methamphetamine. The only contingency to this is that he'll be able to release in a PR bond today with a probation recommendation at the time of sentencing, no further jail up front. Obviously, if he violates probation, he can be jailed after that.
Yeah. All right, and Attorney Stecker. Attorney Feldman indicates he's going to be pleading guilty to the count 1 charge. It could be released on bond today, and that provided there's no violations of bond conditions prior to sentencing, there would be no recommendation. There'd be a recommendation of no upfront jail time.
Your Honor, that is correctly stated by Mr. Feldman.
All right. Mr. Truelove, did you hear the agreement?
Yes, sir, and I accept, I fully understand.
Okay, and you want to go ahead and take advantage of that?
I want to get this behind me. I've been here about 7 months. When it's the 18th of the spring month, it'll be 7 months, and I want to get my life right and do better. Very much I learned from this experience. This is not where I want to spend the rest of my life. I just want to be done with the dope and everything to be involved with that. It's no good.
All right, can you raise your right hand, sir? Do you solemnly swear or affirm under penalty of perjury that the testimony you will give in this matter not pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
The whole truth is nothing but the truth, so help me God.
All right, you can put your hand down. Is your name Daniel Christopher Truelove?
Yes, sir, it is.
And Mr. Truelove, they've got your date of birth listed here as November 11th of 1995, is that correct?
November 24th, 1995.
It's November 24th? Okay.
Yes.
We'll make that note, and I don't know, Attorney Stecker, I think your office filed the protected personal identifying information. If you want to, the office wants to amend that so that we make sure we've got the correct date of birth in there.
Will you say the date of birth one more time, please?
He said November, go ahead, sir.
11/24th, 1995.
Yeah, you got it listed as 11/11 in the, on the identifying information.
I will make that change, I will make sure that change is made, okay?
All right, thank you.
Your Honor.
Yeah. Now, Mr. Truelove, I accept your plea here today. I want you to understand you are giving up the right to have a trial, and that includes the right to have a trial by a jury. Do you understand that?
Yes, sir.
And again, if I accept your plea, you'll be giving up the right that you would have at that trial to be presumed innocent until proven guilty of the charges beyond a reasonable doubt. Do you understand you're giving up those rights?
Yes, sir.
You'd also be giving up the right to have the witnesses who accuse you of this charge to actually appear in court, testify under oath in front of you and your attorney, Mr. Feldman. And you'd be giving up the right to have Attorney Feldman question or cross-examine those witnesses. Do you understand you're giving up those rights?
Yes, sir.
You'll also be giving up the right to present witnesses or evidence at that trial in your defense and to have the court assist you in that regard at Attorney Feldman's request by issuing subpoenas so that you'd have that opportunity. Do you understand you're giving up the right to have the court assist you and Attorney Feldman by issuing subpoenas on your behalf?
Yes, sir.
You'll also be giving up the right you have in these proceedings to remain silent and not have your silence used against you. I obviously have to ask you some questions here today, so you're giving up that right you have in these proceedings and that trial to remain silent and not have that silence used against you. You understand that?
Yes, sir.
And then you're also, also going to be giving up the right you have at trial to testify on your own behalf if you wanted. Do you understand you're giving up that right?
Yes, sir.
Now, when you plead guilty as well, Mr. Truelove, you do give up some of your appellate rights. And what I mean by that is that when you plead guilty, you can still appeal a sentence or conviction, but it requires the filing of an application. There's no automatic right, and the issues that you can appeal on are limited because of the nature of the proceeding as a plea. So do you understand that by pleading here today, you are giving up some of your appellate rights as well?
Yes, sir.
And then you're also going to be giving up the right to later come back and ask that I set aside your plea because of some promise or threat that's been made to get you to enter your plea that you've not told me about here today. You understand that?
I understood, sir.
Now, the prosecutor stated the plea, your attorney confirmed it. You obviously confirmed that with me as well, indicated you understood it and wanted to accept it. Let me ask you, other than that agreement, has anybody promised you anything?
No, sir.
Is anybody threatening you in any way?
No, sir.
Are you pleading then to this charge of your own free will because you believe you're guilty?
Yes, I'm guilty. I'm guilty.
All right, so I'm going to take you back. The offense does indicate that on or about December 18th of 2024 that you were in the city of Dowagiac here in Cass County and that you did knowingly or intentionally possess methamphetamine contrary to Michigan statute. So were you here in Cass County in Dowagiac on or about December 18th of last year?
Yes, sir, December 18th, around 9 o'clock in the morning.
All right, and did you knowingly or intentionally possess methamphetamine at that time?
Unfortunately, yes, I did, sir.
Okay, and did you know that it was methamphetamine and that it was an illegal controlled substance?
Yes, I did.
All right. I don't have any further questions then. Attorney Stecker, are you satisfied?
Yes, I am, Your Honor.
Attorney Feldman?
You have a factual basis, Judge.
All right. Let me ask you then, Mr. Truelove, as to that count one charge on or about December 18th, 2024 in the city of Dowagiac here in Cass County, that you did knowingly or intentionally possess methamphetamine contrary to Michigan statute. How do you plead to that charge?
Guilty.
All right. I will accept your plea, find that it is voluntarily and understandably made. It's made with the assistance of your attorney, Mr. Feldman, and you've provided a sufficient factual and jurisdictional basis. And as you've indicated, there are no threats or promises other than the agreement stated on the record. What I'm going to do is set your case for sentencing on Friday, June 27th at 8:30 in the morning. And so in the meantime, you're going to need to contact the probation department at 445-4404. And they will prepare what's called a pre-sentence investigation report for the court. I'll have a chance to review that, as will the prosecutor's office, and you and your attorney will also have a chance to review that, and you'll also have an opportunity to make a statement at that sentencing on your behalf if you wish to, okay?
Thank you.
Now, I want you to understand two things. Obviously, there's an agreement here today that your bond will be reduced so that you can get out today. So I'm going to go ahead and reduce your bond from a $20,000 cash surety to a $20,000 personal bond, personal recognizance bond. Also, there's an agreement by the prosecutor that there would be no upfront jail time at the time of sentencing. But I want you to understand that if you violate any terms of your release or commit any other offenses, that the court would revoke your personal bond, and that the agreement of no upfront jail time at the time of sentencing would no longer apply. Do you understand that?
Yes, I understand that. I do have one quick question, if you don't mind, sir.
Go ahead.
No upfront jail time, what does that mean?
That means you'll get credit for all the time that you've already spent, and that the court will not order and the prosecutor won't recommend any additional time.
Okay, thank you.
Okay, unless you, of course, violate. Then obviously the prosecutor's not bound by the agreement, and the court wouldn't be bound by that, okay?
Okay, I understand that. I appreciate you explaining that.
Okay. Now, two other things too. When I look at the original paperwork, it listed you as homeless. So if you're going to be released, where would you be released to? Do you have an address for us?
It's your address, yes. It's 206 New York Street.
And that's in
Dowagiac, Michigan.
Dowagiac, okay. And do you have a phone number?
I have one you could contact my mother at, and she can get over me. Right now, I'm in the middle of getting a cell phone.
Okay, so what is your mother's phone number in case we need to get a hold of you?
269-757-2077. Her name is Becky Kelly.
Becky Kelly?
Yes, sir.
Okay, and does she live at the 206 New York?
No, sir.
Well, now, whose home is 206 New York? Is that yours, or?
It's mine right now with my girlfriend at the time.
Okay, all right. So when you leave jail, then I need you to contact the probation department so that you can get that pre-sentence investigation report done, okay?
I'll make the call as soon as I get out.
Okay, we'll do some paperwork, we'll do a memorandum of action, we'll get your bond reduced, and then we'll see you back on June 27th at 8:30 in the morning. If you do get your own phone, make sure you contact Attorney Feldman and make sure he has that number, okay?
Yes, sir.
And then my advice to you is pending sentencing, when I see these cases a lot, Mr. Truelove, in reference to methamphetamine, I would probably tell you what you should do is when you get out of jail as well, go to Woodlands, behavioral health, have an assessment done, and then get yourself engaged in some services, because methamphetamine is one of those things that if you don't get on top of it, trust me, there are gonna be people out there, and you know it, that as soon as they see you, they're gonna want you doing meth with them. And if you do that, you can end up back in jail, and you can end up spending a lot more time in jail. You understand that?
Yes, very much so, I do.
All right, so all right, good. All right.
In jail.
What?
I've done Muslims, so I've been in jail. And I can continue that as well.
Okay.
And the programs that they offer me.
All right, well, good job. We'll go ahead and see you back on June 27th then. Anything further from the prosecutor's office?
No, Your Honor.
Attorney Feldman.
Nothing further, Your Honor, thank you.
Yep, any other questions from you, Mr. Truelove?
No, thank you, I feel blessed.
All right.
God bless you.
All right, we'll go ahead and adjourn. And I believe that concludes our morning docket on Friday, May 30th.
Your Honor?
Yes, go ahead.
There was a matter scheduled for today that we were going to ask for a motion to revoke bond, and Mr. Feldman and I did talk about it.
Mr. Roden was up for settlement conference. We hadn't reached an agreement on the charge, but he was just picked up last night.
And I just charged him.
What's he charged with?
The old charge?
Possession, go ahead, Mr. Feldman.
The old charge or the new charge, Judge?
The new charge.
New charge is possession with intent to deliver methamphetamine.
Okay, I saw that on the press release. Is that he was the one that was just picked up? Oh, into Wajak? Into Wajak?
Billy Rhodes? Yeah, he's not the one that allegedly stole the police car.
No. There was another one I saw this morning, apparently, that been picked up on Orchard Street in Dewajak.
That is correct, Your Honor.
Okay. Well, let me real quick then. When are we scheduled on trial now? On Mr. Rhodes?
24th, maybe?
Okay, it's fine, so we weren't scheduled next week on this.
No.
Okay.
Jury trial.
Okay, we'll go ahead and just leave that on as well, and then if there's any, it's worked out.
I think he wants to revoke his bond, which is fine with me, Your Honor.
Right, and based on the new arrest, that would be appropriate, so we'll go ahead and revoke bond, pending any further motion that's filed.
Would you like the prosecutor to prepare an order on that matter?
No, we'll just go ahead and do a memorandum of action revoking his bond.
Yeah. I appreciate it, Mr. Feldman, I appreciate it, Your Honor.
All right.
Have a good day, Ken.
Have a good weekend.
You too, everybody, thank you.
You're welcome. All right.
Was Swift Insure with you?
What's that?
Well, Mr. Roden did. He was Swift Insure
He
with
wasn't
TC.
Swift Insure. He
He must have done ATC. Can't remember how long ago that was.
I remember.
It might have been.
Yes.
All right.
You do the arrangement that bust and then Mr.